Bienvenidos al programa Legalmente Hablando USA. Este es un programa donde usted se va a poder informar sobre las cosas que pasan en cualquier caso de Workers' Compensation o de compensación al trabajador. Y estamos en este momento con el señor Michael Burgis, que es nuestro invitado y nos va a decir un poco de cosas. Por favor, entiendan de que no todo va a ser por decir así, mecánico o cualquier cosa, sino que estamos en un setting totalmente informal y estamos aquí para explicarle a usted lo que significa, lo que puede suceder en todos los casos de Workers' Compensation. Siendo así, thank you, Michael, for being here with us.
Appreciate it.
This is an amazing day. You know, you opening your doors to us. It's amazing, and we want to thank you for that.
Steve, I'm grateful that you have me here, and I look forward to sharing some of my knowledge with some people who it can pay some serious dividends to. So I'm grateful. Thank you.
I've known you for about 15 years.
Yeah.
What can you tell me? How have you evolved as a person and as a lawyer?
First, as a person, when you first met me, I was single, and I'm married, happily married with two beautiful daughters.
I remember that.
Yeah. So I have evolved very much as a person because I am a husband and a father, and I have evolved so much. And who I am today is, you know, a protector of my family and you know, somebody who wants to raise two beautiful, smart daughters. One of which will hopefully take over this firm. As far as my legal development, I was always pretty aggressive and tenacious and hungry from the beginning, but I have become, you know, every day that goes by, I learn something new, and I am astronomically a better attorney today than I was when I first started, and that has been through trials, depositions, appellate work. But I will tell you that my biggest leap in my lawyering ability, I think, is when I did my first jury trial. I've done a million bench trials at that point, but my first jury trial, I took a case that the defense offered me zero all the way through, and they spent an insane amount of money fighting me. And I had not necessarily the best plaintiff, and I was against one of the best defense firms on the planet who spent an unlimited amount of money and probably anticipated that I would have gone away or they would have buried me, and I didn't. And that I was able to beat one of the best firms with a not so great plaintiff on my very first jury trial, and link punitive damages, and I, you know, got a really good team around me. That has given me the confidence that, you know, I don't think anybody, if I truly put my full efforts into any case, especially with the amazing, talented team of people I've surrounded myself with, nobody's going to beat me. So
You mentioned punitive damages.
Sure.
I understand that in workers' comp we don't have punitive damages.
Sure. Yeah. Let me touch base on that. In California workers' compensation, you're governed by something called exclusive remedy rule, which means you can't sue civilly. In a civil court, say you're rear-ended in a car accident, you can get what's called compensatory damages, things that make you whole. Obviously, nobody can reverse the time and you know, take away the pain that you felt, but in a civil venue, you can get compensated for pain, suffering, lost wages, anything to theoretically make you whole, and again, in the monetary sense, because that's the only thing the court and the jury can award. In workers' comp, no such thing as compensation for pain, suffering, and really penalties are fairly de minimis, meaning very small in a workers' comp context, versus the civil context where the penalties, or what's referred to as the punitive damages, need to be proportional to the valuation of the company, because punitive damages at its heart are designed to do two things: punish the wrongdoing and deter future wrongdoing. And so if a mom and pop, shop did something that warranted punitive damages, well, maybe $10,000 is sufficient because they made $100,000 that year, and that's 10% of their gross revenue that year. But what if the company made $1 billion, $100 billion? Do you think they would feel $10,000? So in the civil context, punitive damages can actually effectuate change, because the more I've litigated in this system, the more, I don't want to say you get jaded, but more you realize that money is the way to effectuate change.
The driving force.
It's the driving force. So it's hard to effectuate change when the punitive damages or the penalty, the damages from what's referred to as a penalty petition in workers' comp is de minimis, right?
Yeah.
So that's the battle. It really is. But again, California workers' comp, and this is what's all right, I'm a little jaded here, and I'm gonna just be honest where I think the system has failed. But
Go for it.
Yeah, because I'm in the trenches and I see this day in and day out. And anybody who's had a work-related injury knows what I'm talking about. But so when the workers' comp department was developing in California, right?
Yeah.
Here's the thing: is they want people to get injured workers. They want them to get quick benefits, right? Well, in a civil context, you have to prove negligence. That is that there was a duty, somebody violated that duty, and that their violation of that duty was the proximate cause of the damages, and then you have to show the damages. So there's this level of burden you have to sustain in a civil court that takes time. So it's referred to as the Great Compromise. So the Great Compromise is this: California's going to have a work comp system where you're not going to have to prove negligence. It doesn't matter if you were negligent. It doesn't matter if your employer was negligent. All that matters is that your injury arose out of and was within the course of employment, which we can go into in a second.
Yeah.
And so for the compromise, because injured workers don't have to prove negligence, and they also are not entitled to pain and suffering and those civil compensatory damages. So it basically says, okay, we're going to limit damages very small in workers' comp, but for that balance in limiting those damages to those injured workers, they're not going to have to prove negligence, and they're going to get prompt, speedy medical treatment. Again, if
prompt and speedy,
I know,
questionable.
Yeah, Steve, you and I laugh about this because we both know it's anything but that. But the California Constitution, Article 4 says, that the California is mandated with a system to accomplish "quote unquote" substantial justice expeditiously without encumbrances of any character. It's hilarious because that's not the system we have, but that was the grand bargain. The grand bargain is, okay, we're going to give up civil damages, and in exchange for limiting those civil damages, we don't have to prove negligence, and we're going to get prompt, speedy treatment. Okay, that was the theoretical grand bargain. And what's happened now is you see that, and I hate to say this, but injured workers don't have a lobby to lobby Sacramento or Congress, right? And who does? Insurance companies, right? So these insurance companies lobby Congress, and the state legislation passes Senate bills. They effectuate laws in labor codes. Those administrative bodies create rules and regulations. So really, there's not a voice for injured workers, and that's why I'm trying to be the voice of the voiceless. But it's hard to do that on a political spectrum, and so I'm trying to battle these big bureaucratic insurance companies and fight the good fight, and hopefully we can effectuate change by creating case law that
matters,
that levels the playing field a little bit, because at some point, when the pendulum swings so far one-sided to the defense, at some point it becomes such a clear-cut violation of an injured worker's due process and constitutional fundamental rights that you would hope that the legal system is here to effectuate change. And for the most part, I feel like it's truly there, although I can tell you right now the appellate level at the Workers' Comp Appeal Board is so inundated and backlogged that I don't see how they could afford injured workers realistic due process. So I often see cases where somebody is appealing and it's a pretty clear-cut violation, and you would imagine if anybody truly knows the law, they would grant in reverse, and then you just see sometimes rubber stamp denied, and it's a bit infuriating, to say the least.
Yeah. So let me make a parenthesis here, okay? And you have an interesting office. I mean, this setup right here is amazing. Can you talk a little bit about this?
Sure. I'm gonna make light of it at first and say that while I might be the boss at this office, my wife is probably the boss at home, and I don't really get to decorate and do some of the things at home. It's a balance, and sort of the office has become kind of like my man cave, where I've got to utilize some of my.
Where you escape?
Yeah, it's my creative. I get to do some cool things, and I grew up with a dad who was a hang glider pilot and was really into vintage aviation, and I just really liked classic cars, classic motorcycles, vintage aviation. I feel, I don't know, it's like a time where things were made of metal versus plastic, and so I wanted to create, when I opened up my office, I wanted to create a conference table that was a statement piece, that it sent a message, that it spoke without me having to speak. And that message is to any defense attorney coming in, sitting in here for a mediation, that they're outgunned, that this table is a true work of art, and if this is my conference table, you can only imagine what the rest of my firm, there's nothing that we do half-ass, excuse my language. We do everything all the way. There are no shortcuts, and I teamed up with an absolute brilliant, amazing artist, Christian Castro, who did this first conference table, and it blew me away with what he did here, and I love the message it sent, and so I have pretty much, Christian Castro and I, this artist, we've developed a very good friendship, and as the office expanded, I wanted to make sure each location had I'm trying to think of a better way to say it, a really gangster conference table that sent a message to opposing counsel that we aren't the ones. Fight the small firms whose office looks like shit, but look at what we do and understand that we're going to get results for our clients, and it's just a statement piece. And so the office has sort of taken on this theme of vintage aviation, vintage racing, and really it's just an opportunity for me to create my man cave and what I'd like to do, because I don't necessarily get to do that at home so much. Shout out to my wife, I love you.
I mean, let's we all love the wives and everything, but wives, we all need a place that we can relax and let ourselves go, because I mean that's important,
I spend a lot of time here, so I think it's important to surround yourself with things that you find are beautiful and conducive to you having, the best experience. Like for instance, kind of not necessarily the best segue here, but like we take care of the team here, right?
Yeah.
You've seen we have a gym in here and an employee lounge. I think it's important that when people are here and they're putting in a substantial amount of time, that they're surrounded by comfort that sort of helps stimulate creativity and productivity. All happy employees are generally more motivated employees that are going to put in more work to help our injured workers.
Correct.
So if we truly care about getting results for our injured workers, one of the best ways to do this is just take care of the team and surround them by a place that fosters their growth, development, and funnels that passion into productivity for the injured worker.
Now, you manage workers' compensation, personal injury, and labor law. Is there another area that you
Sure,
do?
Labor law is kind of a general. I focus more on employment law, and that is really employees' rights. So things like wrongful termination, retaliation, discrimination, failure to make reasonable accommodations, sexual harassment. So we are a plaintiff applicant firm. I do not defend employers. I do not defend insurance companies. I never have. A lot of my team have. And I think it's important to get that insight from their side and bring it to our side.
I would like to do that.
Yeah.
I would love to do that, actually.
Yeah, but so we're a plaintiff. We fight for the people who don't have voices, and we are typically battling insurance companies. I would say 90% of our claims are against insurance companies. 10% of those claims outside of insurance companies are things that generally the employer is not insured for, and that is like sexual harassment or direct action, or sometimes wage and hour violations. But we represent the worker.
So going into that, basically, what basic laws do employers have to comply with? And by this I mean the postings and I know you mentioned something about this before, but can you elaborate?
Sure.
and tell us something?
Yeah, for the most part, employers have several legal obligations, and some of them is one, you're required to post in a conspicuous location, means somewhere where everyone's going to see, generally like a break
Correct.
room of what the minimum wage laws are, what some of the laws under Fair Employment and Housing Act are, or ADA. It'll have what to do if you have a work-related injury and how to file a claim. So yes, there are posting requirements, and at the time of hire, they're supposed to be telling you what those rights are as well. Like for instance, and employers always supposed to have workers' comp insurance. It is the law.
Yeah.
And if an employer is operating without workers' comp insurance, that employer should theoretically be held, criminally and civilly liable for some of those damages. Although we all know how that happens.
Okay, so and I know we're going to get out of context here.
Sure.
But what if an employer does not have, and that happens quite often, I want to say.
Yes, it does. So the question is, what happens when somebody has a work-related injury and their employer doesn't have work comp insurance?
Correct.
Okay, it's kind of a mouthful. Let me just first off tell you, you see these a lot with mom and pop shops. The smaller the company is, the more likely they're not going to be insured. But when you also see this? You also see this in misclassified employees, where they 1099 them. They call them independent contractors, right? In the trucking world, no trucking companies have employees. These are all independent contractors, right? So there's some recent case law that's come down called the Dynamics case, the Supreme Court case that creates an ABC test. And for the most part, people who are 1099 are very often misclassified. And when you're misclassified like that, you don't think you're an employee, you don't think you have those rights of an employee, and if you're injured, you don't think you have the option to get and file a workers' comp claim. Short answer is you do. And if the employer is not insured, there is something that can be done. The vast majority of attorneys have, frankly, no idea how to do it, and even the vast majority of work comp related firms still don't know how to do this. But there's something called the Uninsured Employers Benefit Trust Fund, or UEF for old timers' sake, the Uninsured Employers Fund. And what that is this: the responsible employers, such as myself, I pay premiums for work comp insurance. And a small amount of that premium goes into a separate governmental trust fund. Okay? And that trust fund can be accessed when somebody has a legitimate injury and there's no insurance. So what happens is, it's a bit complicated, but you have to file a separate claim against the Uninsured Employers Benefit Trust Fund, okay, UEBTF. And then it's a bit complicated because there's jurisdictional requirements about properly naming, properly serving all the shareholders, and sometimes these people are very hard to serve with proper notice, so you actually have to do publication. But if you can get through the red tape and the stuff that you have to do to get jurisdiction on this fund, then what happens is this fund steps in as the insurance company and will then resolve the claim or litigate the claim as the insurance company, and then they will go after them civilly. Now, I will tell you that the vast majority of these employers that don't have workers' comp insurance tend to be what I refer to as judgment proof, meaning you can't get blood from a stone. If they have no money, no point in suing them. You're not going to get anything. You're spending good money chasing bad money. But sometimes there are companies that have misclassified and are not judgment proof and have substantial assets. A lot of people don't realize, but in California workers' comp cases, we are governed by something called the exclusive remedy rule, which means we're stuck in comp, right? And we don't get civil damages that we just discussed,
Correct.
pain, suffering. However, when somebody is illegally uninsured, guess what? They don't get the benefits of the work comp system. They don't get the protection of exclusive remedy. So one of the exceptions to the exclusive remedy rule is when somebody's willfully uninsured. And when somebody's uninsured, you can actually sue civilly with a presumption of negligence. But again, it takes a very astute attorney to, one, know how to even file the subsequent injuries benefit trust fund case, and then you have to spend some time and money doing due diligence to see whether a civil case is viable. Mainly what I do is look at the assets and see what we can attach. And if there's no insurance, sometimes that could be one of the biggest work-related injuries possible because you're able to get damages. Let me give you an example. I had two, you see this very often in the construction, right? Is general contractor hires a subcontractor, and let's just say that subcontractor is a mom and pop shop. They go to Home Depot, they hire some day laborers, right? Day laborers, right? Well, guess what? Day laborers, and that shop, that subcontractor that hired them, they have no insurance, right? Nothing. I had two guys fall 30 feet through a roof and are, terribly injured. And the subcontractor, mom and pop, no insurance, no nothing, disappears. What do? Well, sometimes in the construction world, you can tie that up to the general contractor and then attack their policy. So sometimes when the employer is uninsured, you might be able to tie in another statutory employer, in this case, a general contractor, subcontractor. And then in this case, I filed a civil case and I'm probably going for like $30 to $40 million in damages on what would normally in workers' comp be maybe a couple $100,000 case. So it takes a smart attorney to dig through, but there are some times where when an employer is uninsured, that could end up being a blessing to the injured worker if they're in the hands of the right attorney.
So you cover a lot of areas right here, and in essence, I mean, you started with a workers' comp case, but you ended up with a civil case. And that's important because you can attach a lot of other things to it that not necessarily you can attach in comp.
Totally.
Yeah.
So, Steve, sorry to interrupt, but that's also why I started off focusing just on workers' comp.
I remember that.
Right. I'm a certified legal specialist in workers' comp. That was my forte. That was my bread and butter, and that's where I poured my heart and soul in because I think it's the most underrepresented class of people, and I'm always here to fight for the underdog. But then I quickly realized that if I'm not an expert in personal injury, if I'm not an expert in employment law, really it's a disservice to my client because there is overlap in all of this stuff. Correct. Somebody gets injured at the workplace, but there's a negligent third party. Well, if you don't understand personal injury, you're not going to be able to maximize those civil damages and make sure to minimize or shift the compensation so that the client nets the most in their pocket tax-free. Employment law, wrongful termination, retaliation, discrimination. You'll see in work comp context that, hey, they're going to offer you a lump sum buyout, but you have to quit, right? You see this a lot, and they force this. I see this down in court. I hear people signing, voluntary resignation, general releases. If you don't understand what you're signing away, I'm hesitant to say this, but it's malpractice, right? So a really good workers' comp attorney, if they don't understand employment law and at least tangentially personal injury, how could you do that client justice and look at the big picture, right? So that's really where I believe I've sort of developed, blossomed, and why I truly don't believe that an injured worker can find better representation anywhere else.
So you have touched basis on workers' compensation. That's one aspect of law. Personal injury, that's another aspect of law. And labor law, that's another aspect of law. So, I mean, in essence, you are touching on three aspects of law that sometimes a worker, and I mean more often than not, a worker may be involved in all of these.
Absolutely.
Okay.
Well, I'll just tell you right now, the third-party personal injury, the vast majority of work comp cases don't have that. Maybe 10% do. But I will tell you, employment law, so let me generally go over employment law very briefly for like layman's terms. In California, you're considered work as needed. An employer can let you go for any reason, so long as it's not under a protected class. Just like the employee can quit at any time without any issues. However, an employer cannot retaliate, discriminate, or terminate somebody if the substantial motivation for it is under one of those protected classes. What are those? Age, ethnicity, gender, sexual preference, religion. Quasi is whistleblower reporting illegal action, right? And then disability. Every work comp case is a disability. And you will very much see, and again, I also want the readers or the viewers to know that a workers' comp claim is not a lawsuit against the employer. It's just a claim for benefits to the insurance policy.
Correct.
And guess what? Good employers want their team members to get those benefits. Let me give you I pay an extensive amount of money for workers' comp insurance.
I'll bet.
Why do I pay that? So that if one of my team is injured, they get benefits. That's supposed to provide them prompt medical treatment to get them better. A temporary disability while they're outside of work. And then some compensation if they've not had a full recovery, right? So as an employer, I'm wasting my money for my premiums if my employees who need it aren't being utilized or the insurance company's not providing what they should, okay? I just, most of the viewers, they should know that it's not a lawsuit against the employer. It's a claim for benefits to the insurance company. And all of what I'm doing is really fighting insurance companies, and the employer shouldn't be mad about this. The employer should be, if a good employer wants to protect their employee, and they should be just as furious, as the injured worker is, that the insurance company is not, doing them solid, right, and taking care of them. But again, some employers are bad.
Yeah. I mean, we're gonna go into that a little bit later.
Quite a lot of employers are bad, and when somebody files a work-related claim, they think it's money out of their pocket. They think this is a bad person, that this person's litigious, and they've identified this person as somebody they need to get rid of, right? And they're smart enough not to put in an email like, "Hey, this guy filed the workers' comp. We got to fire him." It's never going to be
okay.
there.
So what happens? Yeah. What happens? I mean, because this. I mean, I know this happens a lot. What happens to an employer when an employee files a workers' comp and he's fired?
Okay, so let's go with this. First off, as soon as an injured worker files a workers' comp claim, that gets communicated to the insurance company. That insurance company, usually via an adjuster, will call the employer and conduct an investigation to see if the injury is legitimate or not, really to try to get information and to see if they can deny the claim, okay? Now, if the employer, subsequent to reporting of an injury or subsequent to filing a claim, feels like they're retaliated, and it doesn't need to just be terminated. Most people think, well, they haven't terminated, there's nothing I can do. That's not necessarily true. They were going to get a promotion, now they didn't. Their hours got cut. They shift their job from what they would normally do to something like punitive, like sweeping out. I've seen this all the time, right? So I want to be clear that discrimination and retaliation does not need to just need to be wrongfully terminated. It can be many things, okay?
Right.
All that means is this person is now treated differently than somebody similarly situated who did not report an injury, who did not file a claim. Now, there are, in California, California has some good things and it has some bad things, right? But I will tell you that California as a whole is the most pro-employee state in the nation, in my opinion, okay? California is here to protect injured workers, and there are some things that are set up to incentivize attorneys to fight the good fight. For instance, this is the typical case, and this is literally almost every one of my employment cases and jury trials. You have a company that has $1 billion, and then you have a damn near minimum wage Hispanic worker who gave their all to this company, and as soon as they report pain, symptoms, they get discarded like a piece of trash, right? Now, look at the relative bargaining positions of them. A $1 billion company with all the best lawyers money can buy.
There's no way an employee can fight against that. Yeah,
they can't. And if they did, they're just going to get demolished, right? So California is one of the few states that actually recognizes this and says, hey, attorneys, guess what? We are going to incentivize you and reward you if you're willing to take on that David versus Goliath. And you know what that means? If you eventually go to trial and you succeed on your causes of action to show that the employer failed to engage in the individual interactive process, failed to make reasonable accommodations, wrongfully terminated, retaliated, discriminated, whatever those causes of action are, under FEHA, Fair Employment and Housing Act, if you succeed and win $1, we're going to pay you your statutory attorney fees on top, because we understand that this is a minimum wage worker and those damages may be relatively small, and that the litigation costs alone might be worth more than your overall demand on the case.
Yeah.
But if you're willing to fight for that underdog and take it all the way to verdict and hold that bad actor accountable, well, we're going to open the door to get you statutory attorney fees for that. And then we're also going to open the door for punitive damages. And punitive damages is the one way you could effectuate change in this system. And again, remember, punitive damages need to be proportional to the valuation of the company.
Yeah.
Money is the way you can sometimes change. And so I gear every one of my cases up for trial, knowing that I'm going to try the case and I'm going to argue for every penalty or punitive damages I possibly can. And I will also tell you that that's one of my, the secrets to my secret sauce, right? It's like, well, how am I able to get such large settlements for my clients? First off, there's no real secret. The secret is called hard fucking work. Excuse my language. It's just hard work.
Yeah.
People can talk about it all day long. You got to actually do it. I don't say, hey, this is what I'm going to do. No, I do it. And then I say, now, if you want to offer some money before, the adjudication of this penalty petition has come down, have at it, right? So I think it's just really important that attorneys hold the bad actor accountable, and the only way to do that is to go straight to trial. Do the penalty petition, raise punitive damages, develop the record you need to prove those issues. And, insurance companies, if you truly know how they work from the inside out, they're massive companies, right? And they don't care about people. People are just numbers. They care about money, right? Numbers. But if you ever get a penalty petition in workers' comp adjudicated and they're hit with penalties, they have to code that in their system as penalties. Best believe when that gets coded as a penalty that adjuster or supervisor, somebody looks in and people should get into trouble. So very often, one of the ways to get a very large settlement for your client is to leverage that, okay? And that is that, for instance, in workers' comp, if the work comp insurance carrier didn't do what they were legally obligated to do, that means somebody messed up. That means it was either the adjuster or their counsel representing the adjuster. Now, and I can just tell you, every case you look at in workers' comp, the adjuster's messed up on probably a handful of things, okay? But the real heinous ones, the ones that have an impact on my client, you file that penalty petition. And you know what's going to happen? That adjuster is going to want to if the adjuster is the one that messed up, they're going to want to throw a lot of money at that case, settle it, and bury it so it doesn't go away and there's nothing coded. If the attorney was the one that messed up, they're going to recommend a higher amount of money to settle, to bury it as well. So really, penalties is very, very important. And again, I represent my client. I'm here to effectuate change and create good case law and hold bad actors accountable. But at the end of the day, if they overpay my client and my client wants to take it and it involves dismissing that penalty, it's my client's right. And that's a big part of how I get very large settlements that are probably larger than even the file typically otherwise would be worth because of penalties.
So I had the opportunity to interview Mr. Javier Lechuga, who is your general manager, I believe so.
My COO, Chief Operating Officer.
Oh, okay.
Yeah.
So, excuse me.
Yes.
So we maybe he can tell us in his own words, because I did a little interview with him. When you do an intake.
Yeah, so I think I know where you're asking, Steve. And so first off, very often an employee will want to file a claim. They have no idea if their employer has insurance, or if so, what insurance company that is. And they could ask them, and the employer's not being forthcoming with that information. All I can say is all an injured worker has to do is get represented by an attorney, and the attorney can handle everything. And so from my perspective, the first thing I do is I very often know who the carrier is of the employer because I've litigated cases against them already.
Right, so you have a lot. You have a lot of cases.
I have a database, and I can quickly pull and figure out who that insurance is. And if I can't, then I contacted them. Once I have a notice of representation, I contact them on behalf of my client, and I get that information. And if they're not being forthcoming with me, I can file hearings on this issue. But we can also do something called a WCIRB. It's basically like a search, and anybody who has insurance is supposed to be on a database. So I can pull from that database and see who that database says is their carrier. However, sometimes that information is wrong. So
correct.
So you know, it's not hard to find out if it's wrong because I find out who they're purporting their carrier is and or who the WCRB says the carrier is. I file against that carrier, and that carrier will very quickly come out and say, I'm not the one.
It's not us, it's somebody else.
Somebody else, and then we can figure it out. So don't worry about finding out who has the insurance. Any attorney can do that relatively quickly, okay? And you know, that is finding the insurance and or if there is no insurance, doing a UEF case.
So, okay, so can you tell me more or less how long, because you know, some clients, some people, you know, they're waiting all this time for you to find out this information. Now you effectively, you know, have said you have a database and blah 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 blah. But if you don't have a database, how long usually does it take to get that information?
Again, absolutely the opposite of what the California Constitution is supposed to say, right? Expeditious without encumbrances of any character, the grand bargain, right? Frankly, it's absurd, okay, what's going on. So one, when you file a claim, theoretically the carrier has 90 days to admit or deny the claim. However, the law is set up that the carrier is supposed to provide and pay for treatment up to $10,000 until they've denied the claim.
Right.
So a very smart attorney can actually expedite this and making sure that that happens. But typically what you see is this. You report your claim to an employer, and the employer will send you to one of their company clinics, okay? Concentra, you know, these type of things, right?
Yeah.
And anybody knows that these company clinics are not looking out for the injured worker's best interest.
Yeah.
They are beholden to the employer. They are there to find, you know, no industrial causation or, you know, no temporary disability, and say the employee is fine and send them back to work, right? So theoretically, the employer is supposed to have medical control for the first 30 days. So if they do what's right and they send to their company clinic, theoretically they're supposed to have control for like 30 days, okay? Now, I will tell you that that's theoretically the law. However, any good attorney can probably get around that because an injured worker is obligated to treat in the defendant's medical provider network and have medical control for the first 30 days, subject to a prompt delivery of benefits. But if there's a denial of care, there's a plethora of case law that allows you to opt out of that and go treat with a doctor who's going to look at your best interest and theoretically get paid outside of the defense medical provider network. And that's a big thing that's going on that we haven't addressed yet, Steve, is that, you know, insurance companies now in workers' comp have developed these medical provider networks. So, and the law, because they've done a very good job of lobbying to create law,
Right.
something called Senate Bill 863 that basically decimated this current system and took away the rights of the judges to hear disputed medical treatment issues. But, you know, we got to treat in the medical provider network with their doctors. Well, believe me, their doctors know that if they truly advocated for the injured worker, which is technically what they're supposed to do.
They never do it.
There's a Hippocratic oath. The doctors are supposed to do no harm. And the law establishes that they have to address the whole person, everything that could be part and parcel.
Right.
So you'll see a catastrophic, like, specific injury with all kinds of body parts, and they'll accept the case and accept a finger or a wrist. And then that doctor was like, well, I can only treat the wrist because that's the only accepted. In the meantime, they have 10 other body parts that are in excruciating pain, right? So, but we're obligated to treat in these networks with these doctors that, again, if they found everything for the patient, they would get kicked out of the network, or they would redo the network, and it just would so happen that they're no longer in it. So we're currently in a system that...
it's not perfect.
It's not perfect, and I personally believe that without an attorney, you are absolutely going to be screwed. You, even with an attorney...
that doesn't know what he's doing.
That doesn't know what they're doing, you're going to get screwed. But I mean, without an attorney... you're just going to be screwed by this system. You really are. I'll take this from firsthand experience. Before I was a lawyer, I worked for the city of LA. I managed lifeguards. I had a very serious work-related injury. My leg popped out, dislocated. I was so terrified that they would find out that I hurt myself that I was afraid to even tell them. And I would never file a claim because I didn't want to be retaliated, and I didn't think I would. Had I known now, I would have got better medical treatment. I would have got compensated for some time off, and I would have been entitled to some compensation that I never got. So just, for any of the viewers, don't think you can do this on your own. You really do need an advocate, and just keep in mind, in workers' comp, I take 15% on a contingency basis. As long as I increase the overall amount of benefits and money you would get more than 15%, it's a net benefit.
Yeah.
But I'm talking like 10 times over. You know what I mean? So now this person gets they can take that burden off their shoulders of, what do I do, this whole system, by getting an expert to advocate for them. So they're going to alleviate stress, alleviate some of that, unknown, have somebody that's going to partner with them in that recovery journey, and then make sure they're taken care of, and the net benefit is like, it is a no-brainer. But again, making sure you're with the right attorney. Yeah.
So you touched a little bit on something very important that I consider very important, and that is the fear that employees have to report a claim because they're afraid to get fired or otherwise. Can you tell us a little bit about that? Because, like you said, I mean, you could have been better treated, done everything.
I'll give another example. I used to work for Budweiser. While I was in law school, I worked nights and weekends in the lab at Budweiser. When I would leave the gate, there was a big sign that said the number of days that they've gone without a lost time work injury. And if somebody got injured, it went to 0. It was very obvious they were discouraging people from filing, and it was palpable. Like you could feel that. It is 100% illegal. An employee absolutely has the right to file a work comp claim whenever they believe they've sustained an industrial injury. It is illegal for the employer to discriminate, retaliate, or anything of that such. And there are systems in place to help those people. And I will tell you right now, if you get represented by competent counsel, you'll see that your job is going to be protected, because an employer says, shit, they just got represented by a really good firm.
Right.
Don't terminate them. Make all reasonable accommodations. It's the people who aren't represented, who they think won't get represented, that they take advantage of. So again, it is illegal to discriminate. It's illegal to retaliate. There are systems in place, and this is the great part. So in workers' comp, there's something called a 132A. That's technically a lawsuit against the employer that's heard at the Workers' Comp Appeal Board. And you can get up to $10,000 plus lost wages. To be honest, that's a slap in the wrist, okay? But sometimes I file that claim and use that as a tool to do discovery and take depositions, because the real claim is the civil claim. And the exclusive remedy rule does not bar the employer from being sued civilly for employment law violations.
Right.
Again, retaliation, discrimination, wrongful termination, that type of stuff. So quite frankly, anybody who's watching this, everybody has rights. don't be afraid of, if you're afraid that your employer is going to be discriminatory or retaliatory, before you even file the claim, come in and speak to an attorney. An attorney can break that down for you, can put you at ease, and then they can file the claim on your behalf. And now that you're represented, they can't even talk to you about the claim. They have to go through me, the attorney. Now, they can communicate as to your ability to work, no problem. But again, they can't talk to you about your claim. They have to do it through the attorney via a deposition. And just remember that if you file a claim and you're not represented and you openly communicate with the employer or the insurance company, anything you say can and will be used against you. So it's real important that just people shouldn't be afraid. Employees have rights. In fact, in California, you have some of the greatest rights anywhere else in the state. And if you exercise your rights, you should be protected, especially if you have an attorney. And I will touch on one place: undocumented immigrants.
Okay. I was just going to talk about it.
Right. This is undocumented people who may be here illegally. Guess what? It doesn't matter. Okay. California is one of the few states that have evolved to understand the big picture. We're like the 5th biggest economy in the world right now, almost the 4th.
Almost the 4th, yeah.
The vast majority of all the hardworking people who are doing the jobs that most people don't want to do are hardworking, undocumented immigrants. This is the farm work, right? All the field work. These people, they have the same rights as somebody who's been born here for their entire life. It is illegal to take advantage of somebody's undocumented status, so they should not worry about that at all. And if an employer is physically threatening with that, like, hey, you report this, we're going to call migre on you or immigration on you, right? They should instantly give a call, because their immigration status could actually be protected if they've been involved in injury or retaliation. You can actually protect them when they're being threatened in that regard.
Yeah.
But again, that's usually going to involve getting a good, competent lawyer.
Okay. So I'm going to pause for a minute, and we're going to let Javier Lechuga tell us basically what you do to include, some of the things that when an employee doesn't have coverage, or when he does an intake. Let's have Mr. Lechuga talk to us about it.
La verdad es que, cuando no tienen seguro, le dan un TIN number, ¿ok? Pero el trabajo le dieron, horas, le pagaron su ingreso, su servicio, y por eso tienen derecho de, a llenar un reclamo para, cuando están lesionados. So, con seguro, sin seguro, sí tienen derecho porque sí estaban trabajando. Y esos son por las personas que son trabajadores, laborales. Hay también contactistas independientes que no tienen derecho. Pero buena pregunta, porque hay veces que una compañía, un empleador pueden decir que tú eres una contactista independiente. En realidad eres un trabajador de una compañía, pero como pusieron en el papel, como le están pagando, está mal, y por eso no vas a poder colectar beneficios. Pero si me comunican o hablan o una consulta gratis en la oficina, podemos ver si tienen derechos para pelear que sí son empleados laborales, y luego tienen derecho de colectar estos beneficios por parte de Workers' Compensation. So, esas son cosas que tenemos que determinar en la consulta gratis, pero lo ofrecemos para toda la gente para que pueden estar bien informados y ojalá que se recuperan de sus lesiones, sus quejas, sus adoloridos, y se muevan adelante con su familia y trabajando hasta que el momento que están listos a retirar, ¿verdad? Y mucha gente están trabajando hasta que ya ni pueden llegar porque están bien dolorido, golpeado y sin dinero. ¿Cómo van a poder colectar ese tratamiento médico? Pero con la ayuda de una oficina de abogados podemos conseguirles doctores sin ningún centavo de su bolsa pagando por esos médicos, y pueden obtener esos MRIs, rayos X, terapias, cirugías, esas consultas gratis para la gente que están, lesionados.
Okay, estamos viendo, well, I just want to remind you, everybody, that, this is in Spanish because, we have a lot of Spanish speakers,
of course.
individuals, and this program, hopefully, a lot of Spanish people will be looking at this, and possibly they will call you, that's what we want.
Yeah, and see, to be blunt, everyone in my office speaks Spanish. I have, interpreters on everything, so it doesn't matter what language you speak. We can communicate with you and make sure to take care of your rights.
Yeah, I mean, I see you have Armenian people and you have all kinds.
We have pretty much every language that needs to be spoken. We probably have somebody here that speaks it, and if we don't, we can get a certified interpreter to come take care of you.
So now you were, while Mr. Lechuga was talking, you were talking to me about some things that you want to talk. I just want to give you a chance to just be yourself and talk about it.
Yeah, I can tell you that a lot of people have questions about workers' compensation and employment law. And a lot of people have questions of how does the settlement work? How does that, what am I entitled to? They want to decide, is the juice worth the squeeze? Is it worth filing a claim? So let me just be really clear on a quick summary of benefits. First off, most employers, if you look at your pay stub and they pull out money and it's going to the EDD, Employment Development Department,
right.
There's money that goes into an account for if you are unable to work, you can get what's called SDI, State Disability Insurance. If your employer lays you off, you can get unemployment. It's the same pot. Okay, so there's some money there that people should realize.
Like 3 or 4 different pots.
Yeah, exactly. So the first pot is a pot that they even pay into for a while, and then you can access that, and that's through Employment Development Department, EDD. So that's State Disability Insurance or unemployment insurance. That's one pot. The next is workers' comp. Okay, workers' comp is, if you utilize it correctly, can be a very, very good tool to take care of injured workers, and it's supposed to pay you temporary disability when you can't work. So if a doctor is saying you can't work, it's supposed to pay 2/3 of your salary, tax-free, subject to a max and a minimum, while you can't work, up to 2 years, okay, with some exceptions. And then you're supposed to get medical treatment to help get you better, right? And then once you've had all that treatment and you reach your plateau, what's referred to as maximum medical improvement, or in old term language, permanent and stationary,
yeah.
If there's an indication that you've not had a full recovery and you have some residual disability, you're entitled to compensation for that disability. And permanent disability, not a huge amount of money. Generally, it's paid at $290 per week. The greater your injury is, the longer the duration of those payments you receive. And then you're entitled to lifetime future medical for all those body parts or injuries that are industrial, and that means that those injuries arose out of and was within the course of employment. And again, negligence doesn't matter. Employer negligence, your personal negligence, it doesn't matter. There's also a claim for something called serious and willful misconduct. If the employer's actions were beyond gross negligent, or if they were like cited by Cal OSHA before for a violation and they didn't adhere to the safety order, but for that failure to adhere to that safety order, this injury wouldn't have happened. Serious and willful misconduct. That claim in of itself produces a 50% increase in all overall benefits. Okay? And that's in the workers' comp context. There's also that 132A we discussed, which
right.
is a disability to claim it in workers' comp. Now, the workers' comp claim, when that's done, there are really 2 ways it can settle. A claim can settle. One is called a stipulation. The other is called a compromise and release.
Right.
Now, what a stipulation is, all the parties are doing is stipulating what body parts or injuries are industrial. You're stipulating what your respective percentage of permanent disability is. And first off, I can't tell you how many of my clients are like, well, I don't want to have permanent disability. The phrase permanent disability is a legal abstract. It doesn't mean anything. It is literally to determine how much compensation you're entitled to.
Right.
So best believe you want the highest amount of permanent disability to get you the compensation that you're entitled to.
Correct.
And under a stipulation, you're locking in that compensation. And then future medical, theoretically left open for the rest of your life. I say the word theoretically because we all know that workers' comp tends to deny almost the majority, and it's a bit frustrating, but theoretically, lifetime future medical. Now,
right.
That's called a stipulation. Now, if the parties are unable to stipulate what your injuries are, or what the body parts are, or the respective amount of permanent disability, then you go to trial. And the trial decision is called a findings and award. So instead of the parties stipulating it, the judge is finding it and awarding it. And it's the same thing as a stipulation.
Correct.
Now, I can never force an insurance company to do a lump sum buyout called a compromise and release.
Right.
I can't force them to do it. A judge can't force them to do it. Nobody can. But a good, competent attorney very often could be such a pain in the ass in the insurance company that they're paying a lot of money to fight the attorney. They're paying all those med legal costs, and there is exposure that they're represented. So sometimes I can get an insurance company to say, all right, here's one lump sum settlement, to close it out. My job on a workers' comp claim is to essentially try to work up both options. Option one, the stipulation. Option two, the compromise and release. My job is to tell my client what I legally recommend and why, but it's their choice. I'm here to just go over the pros and the cons of each. Whatever my client wants, it's their right. And at the end of the day, if their offer isn't reasonable, my recommendation is let's go to trial and ring the bell.
Right.
And very often, the only reasonable settlement comes the eve of trial when you're at trial, because the vast majority of attorneys don't try cases and the insurance companies lowball until the day of trial and then like, okay, you got me, and then so that's the workers comp side of things. And then on the in the employment side of things, if there's a good employment law case, the damages are exponentially higher because of compensatory damages. Same thing with civil. If you're in civil, the damages are much higher. Okay, but let's do a little. Let's talk about them briefly, because my attorney fees generally in workers' comp is only 15%.
Right.
And then all those medical treatment, all the doctors I send to all that workup, guess what? That does not get deducted from the settlement. That gets paid for on top of the settlement by the defendant. I make sure that any doctor I ever send my patients or my clients to, or none of that gets deducted from theirs, and I only take 15% on the workers' comp.
Right.
Now, in contrary, the civil, the attorney fees generally are much, much higher, and those medicals get deducted from the overall settlement. So it's really important that if you have a hybrid case where there's a personal injury as well as a workers' comp, or a workers' comp as well as an employment law context, you want to work the
different angles.
You want to work the different angles, build the record, but sometimes you're able to build the record up to get a really good civil result, but then not deduct those medicals through the civil and run it through the workers' comp. So there's ways to make sure that in the end, the injured worker nets the most possible. And my firm, we don't just look at the biggest settlement amount, which is the biggest attorney fees. No, sometimes I lower the workers' comp case because the personal injury case is worth far more.
Right.
Vice versa. I look at what is going to be the bet net for my client after taxes. I take into consideration Social Security, impacts on that, everything, because we look at our client as a whole and make sure that they have the best outcome. And, yes, I'm talking monetarily right now, but, my motto is recovery for the injury, and it's not just monetary. It means physically,
mentally,
emotionally, right? We are a partner in this journey with these people, and my goal is to get people back in the workforce, back towards being a productive part of humanity. And, for my Hispanic clientele, which is the vast majority of my clients.
So, by the way, what percentage of your firm are Hispanic clients?
I would say north of 60%, because at the end of the day, just remember this. The vast majority of my clients are for work-related claims, right? And the people who tend to get the most injured are the blue-collared, hard-working people.
The ones that get hurt.
Exactly, right? It's not the white-collar, boss sitting in there, maybe they get carpal tunnel. But
some corner office with windows and everything.
Yeah, so we represent the salt of the earth, the hard-working people, and those typically tend to be, the vast majority of those are Hispanic, hardworking, great people. And so I just want to make sure, especially for the Hispanic community, again, doesn't matter if you're undocumented, you have rights. If your employer is threatening you, you have rights. And at the end of the day, call us. Everything is, we do 100% free legal consultation. Anybody who wants to charge a person an hourly rate, stay away from that attorney. Okay? A good attorney will do everything for free at the outset and will work off a contingency, which means I make a percentage. The more I get for you, the more I get for me.
At the end of the case.
Right. Not what, and if hypothetically we were ever lose a case, won't happen, guess what? They owe me nothing.
Yeah.
It is my money that I'm putting in expert fees. It's my time, all this. I take 100% of the risk, again, because I'm confident in my results, and I realistically know no one's really beaten us, especially because we signed up legitimate cases.
Yeah.
Yeah.
So I have one more question that I interviewed Mr. Lechuga. We're going to run that so that he can answer those questions.
Buena pregunta. Exactamente. Cada lesión lo tienen que reportar cuando están lesionados. Si no lo reportan, pues cómo van a poder recibir atención para tratamiento médico, incapacidades, tal vez, compensación para sus lesiones. Pero hay dos diferentes tipos de clientes que me hablan. Uno que ya han reportado la lesión y no le han dado el tratamiento que necesitan y ocupan la ayuda de una oficina de abogados. Y hay gente que han reportado y han tratado de pedir ayuda médico y la empleador no le está ofreciendo el tratamiento médico, so me contactan para que les doy un consejo, les doy la consulta gratis, le digo sus derechos y si hay reclamo, podemos mover adelante con sacando cita médico gratis por parte del caso. Si tienen derecho de incapacidades, podemos ayudarle para que colectan ese cantidad de dinero que están elegibles porque tienen derecho a recibir con seguro y sin seguro. Y esa es la cosa con las personas lastimadas que no saben si tienen derechos o no cuando no tienen papeles.
Okay, Mr. Burgis, I mean, we could sit here for hours and hours discussing not only workers' comp, but as you mentioned, PI and labor law. I would like to thank you for spending this time with us, and this is really, really, really nice. I hope that you are content with what we did.
Steve, I appreciate the time. I appreciate really what you guys are doing about getting this out into the public and letting, especially Hispanic people understand their rights and what's going on in the system. So thank you for taking the time with me and allowing me to take part of what you guys are trying to accomplish here. I appreciate it.
Thank you. A la gente hispana le queremos decir que estamos aquí para poder informarles, para poder darles estas posibilidades de poder aprender las diferentes cosas que pasan en un caso. Y queremos decirles de que esto es solo el principio. This is just the beginning. So, I'm sure that you would want us to come back. We want to interview you again. So, if you don't mind,
I will absolutely welcome it. And if you compare my YouTube videos I made myself 10 years ago to who I am now, I'm a very different person, and I would love to see where both of us are in the not so distant future.
I remember when I first met you, and you were talking about some DJ, some party, and some DJ, and you were I don't know it's funky when you think about all this, and then now you are married, and you have 2 daughters.
Yep.
So that's a wonderful thing. I want to thank my audience. Thank you. Thank your staff for allowing us to, shoot all those videos. And you know what? We'll be back next time.
Appreciate it. Thank you, man.
Thank you.
Thank you.